Please be seated. I know you're all enjoying yourselves networking and talking, and it's important, but we have a wonderful next panel on judicial interference. I just want to put our luncheon speaker in a little bit of context. When we're thinking about organized crime, and we've talked, as Tom Firestone did, about corporate raiding and how many of the red notices are related to that, often the intimidation of the corporate raiders is done by the organized crime figures that were just referenced before in the talk. And also, they crop up in other cases, such as Jamie Nowodeh will talk about of the Prevezon case in New York. So these figures are not just parts of a colorful story, they're parts of the problem of Interpol red notices and of judicial interference. And with that, I will turn us over to this fascinating panel, because I know these people, and Mr. Jeffrey will convene and introduce everybody. But you have their bios, so we'll spend more time on the substance than the introductions. Thank you.
Great, thank you. Good afternoon, everybody. My name is Michael Jeffroy. I am a visiting fellow at the National Security Institute at the law school right next door, so very happy to be here to join my colleagues here with this very interesting panel. So following on the morning's panels, we can now turn to foreign interference in our legal and judicial systems. We've got a great panel with, they'll be able to offer unique perspectives from their own practices, their experiences, and some outstanding academic study. Much has been written about the Putin regime and how it has manipulated Russia's law enforcement and judicial communities to support its kleptocratic efforts. There's a great paper out over at the Atlantic Council by Anders Ashland, and he wrote recently, Russian state power legitimizes lawlessness and gives it official state sanction. This makes it easier for those actors to successfully use the U.S. legal system, which tends to give foreign governments the benefit of the doubt in legal cases. Thus, the Kremlin has exploited the U.S. judicial system to advance Russia's state corrupt raiding and expropriation schemes. Just as the Russians have recently attacked our electoral system, they appear to be making deliberate use of our legal and financial systems to further their expropriation of private property, corporate raiding, and political persecution. In the U.S., the Russian actors have made good use of various U.S. laws. Just to note a couple, Section 1782, Title 28 of the U.S. Code provides that a party interested in foreign proceedings may seek judicial assistance from the United States District Court to obtain discovery of persons in the United States. In similar fashion, Chapter 15 of our Bankruptcy Code allows representatives of a foreign insolvency proceeding to bring an ancillary action in the United States, allowing for further discovery of property and the affairs of the debtor in question. Additionally, as we'll probably hear a little later especially from Ben, the principles of international comity support that U.S. courts will frequently enforce the judgments of foreign courts where appropriate. One area where Russia has made deliberate efforts to abuse the international U.S. legal systems, as we all heard this morning, is via Interpol and the misuse of the red notices and related processes. Interpol makes it possible for its 192 member states to exchange information on criminal activity that crosses national borders and to seek and locate arrest persons with a view towards extradition or something similar, perhaps just to harass somebody. In principle, the Interpol system's a great thing. Three of us on the panel today are former assistant United States attorneys, myself included, and I expect that we would all agree that Interpol is an outstanding tool upon which the United States justice system, criminal justice system, makes good effect. Problematically, however, the red notices, diffusions, and blue notices are increasingly being used not just by Russia, but by several nation states to target political opponents, activists, journalists, or refugees, and to further their kleptocratic ends. This is happening despite Article 3 of Interpol's Constitution, adopted in 1956, which specifically states they're supposed to stay away from political issues. With a couple small data points that I thought were really interesting as I was preparing for today's panel, with regard to the red notices and how their use has dramatically increased over time. Now, some of that's part of technological developments that Interpol has put in place with its technology and its communication systems. But in 1998, Interpol published about 737 red notices. In 2017, they published over 13,000. In 2015, they published over 22,000 diffusion notices. So huge use, huge dramatic growth in all of those tools, not all for good. One particularly poignant example I thought was in 2016, following the coup in Turkey, the Turks apparently requested over 60,000 red notices be published, and they were declined. But I think this dramatic increase in the red notices is due, as I said, in part to technological advances with Interpol launching its I-24/7 communications network. This allows for police agencies around the world to communicate directly with each other, not just with Interpol. And it makes, it greatly increases efficiency, but it also greatly increases the opportunity for abuse. In short, the flood of red notices makes it really easy to hide the bad ones. There's been a lot of excellent academic work on these issues. The Atlantic Council, the Henry Jackson Society, Heritage Foundation, they've all published some really good papers on this issue about foreign abuse of Interpol, but also foreign interference in the United States judicial system. So I recommend those reports to you. They're really solid, especially the Atlantic Council. It really gets into details of some very specific cases. Before I introduce our panel, two very recent events. One in April, Senators Rubio and Leahy sent a letter to the Attorney General on behalf of a bipartisan group of senators, noting their concern about the Chinese abuse of the Interpol system and red notices to harass dissidents living abroad, several of whom were living in the United States. And just a couple days ago, on Monday, the New York Times published an article noting the travel ban that the Chinese imposed upon Victor and Cynthia Liu and their mother, Sandra Han, all United States citizens. Victor, born in the United States about 20 years ago. They went to visit their grandfather, apparently, and they were detained in China because the Chinese want to locate and return their father to answer for some criminal charges there. So travel bans, Interpol abuse, invading our judicial system for their benefit. I think all these things that weave together, and hopefully our panel will be able to have a great discussion about these things. So it's not just Russia, it's China, it's Turkey, it's the whole slew of other actors. But let me introduce our panel. Let me start with Jamie. Jamie Nawadé is a former federal prosecutor in the Southern District of New York. She's now a partner at Kelly, Dry & Warren. She is in New York City, is that right?
Yes.
Is still in New York City. Can't bring her south just yet, but she focuses her practice on government investigations, white-collar defense. She advises and represents organizations and individuals in government investigations across the spectrum of federal laws and False Claim Act and forfeiture matters. She was an assistant United States attorney in the Southern District for 7 years. She worked on both criminal and civil matters, money laundering, and worked in the criminal divisions, what used to be known as AFMLs, Asset Forfeiture Money Laundering. They've changed the name since then. But she was actively involved in the Prevezon Holdings case, and I think she'll have some great insights from that experience, which is a case that arose out of the murder of Sergei Magnitsky. Jamie also recently appeared on MSNBC to talk about Russian interference in our prosecution of the Prevezon case. So, Jamie, looking forward to your remarks on that. Next door to her is Tom Firestone. He's a partner at Baker McKenzie here in Washington. He spent about 14 years in the Justice Department, where he worked as an assistant United States attorney in the Eastern District of New York. But he also served as the DOJ's resident legal advisor at the embassy in Moscow for a number of years. He currently represents at least 3 individuals in proceedings before Interpol, so he'll have hopefully some insights in that regard. And I think of note, Tom was so effective in his legal work that in 2013 he was declared persona non grata by the Russian government. So Tom, congratulations. Immediately to my right, a man that needs no introduction, but I'll give it anyways, Ben Wittes. He is a senior fellow and research director in public law at the Brookings Institution. He is the co-founder and editor-in-chief of the Lawfare blog, a fantastic blog, and really, you're setting the pace, Ben, so thank you for that. He's also a member of the Hoover Institution's Task Force on National Security Law. He's published all over the place. I recommend his reading every day, all the time. He really knows his stuff. And also, don't upset him because he is a black belt in Taekwondo. So without further ado, I thought what we would do is we'd ask Jamie to start off with a few minutes talking about her experiences in the Southern District, more recently, but also with particularity to the Prevezon case.
Thanks. Hi, everyone. So the Prevezon Holdings case that was mentioned was sort of my introduction to all of the topics that are being discussed today. It was also my introduction to Louise, my introduction to Tom, and it was, for me, a pretty fantastical introduction because I grew up outside of Amish country in Pennsylvania. And so to encounter a set of facts like the Prevezon Holdings case that involved a more than $200 million tax fraud against the Russian government, a corporate raid of the sort I'd never encountered or heard anything about before, had to be educated on by Louise, the investigation, of course, by Sergei Magnitsky and his detention and murder, and then a worldwide money laundering scheme that involved moving the proceeds of this fraud through Moldovan and other shell companies around the world until finally a small portion of these proceeds ended up purchasing New York City real estate. So that's the Prevezon Holdings case for those of you unfamiliar with it. And it's an unusual case also because it's a civil forfeiture case. And for those of you unfamiliar with civil forfeiture, it's sort of a mix between a civil and a criminal case. What it is a civil proceeding to seize and forfeit property by the US government because of its connection to some underlying criminal activity. So it's a civil proceeding that requires you to prove that an underlying crime occurred and that the property you're seizing is somehow connected to that crime. So the action that was brought in the Southern District of New York was a civil action to seize and forfeit certain New York City real estate properties because of their connection to this underlying crime in Russia. Now, to take a step back, any case of this sort is going to, especially in dealing with Russia or a similar foreign country, you're going to face two major challenges. One is going to be you're probably going to have some very skittish and intimidated witnesses, which we did in Prevezon as well, and that's been reported on pretty widely. The other one is that it's going to be, I feel like I'm getting a lot of feedback. Okay. The other one is going to be that to prove the existence of this underlying Russian tax fraud, you're going to need tax records from Russia, you're going to need bank records from Russia, you're going to need incorporation documents from Russia to show the existence of this corporate raid. All of these documents have to be obtained from Russia, right? So how do you do that? Well, you make use of what's called the MLAT process. And for those of you unfamiliar with the MLAT process, what it is a written request for legal assistance from prosecutors in one country to prosecutors in another country. So the action was filed 2012, 2013. At some point, the US prosecutors sent this legal request for assistance to Russia. And when you send a request like that, you set out, here's what our case is about. Here are the you describe the allegations, and it was a request that was put in after this civil complaint was filed. So it described the nature of the complaint, the records that were needed in order to prove the case, their relevance and why they were necessary. And it's basically saying, please send us these documents and assist us, prosecutor to prosecutor. So some months later, a response comes back from the Russian government that essentially says, we're not going to give you any records because your case has no merit. There's no connection at all between the Russian tax fraud and the New York City real estate, anything like what you've alleged. You've got it all wrong, US. But we'll help you. We'll sort of help you sort out your misunderstanding because you've obviously been manipulated by Bill Browder, who was the individual who, of course, brought the case to the Southern District of New York. So why don't we join hands and we will jointly investigate Bill Browder? And that was the proposal going forward. So you can imagine the challenge that this posed for US prosecutors. I mean, you get this. It's a ridiculous response. And it, at that point, could really threaten the case. How are we going to prove the case without getting any of these documents from Russia? And instead, they're pointing the finger at the individual who referred the case to the Southern District of New York. So what followed was, a lengthy court battle where there were attempts to, all of which is public, of course, where there were motions filed to try to get documents by other means to argue for their admissibility in the proceeding in New York. And while this is all going on in the background, there are significant witness issues that the government had to contend with. Most obviously with Nikolai Gorokov, who has been the subject of a lot of public reporting in terms of his attempts to get documents for the US and to provide them, and then suffering a terrible, so-called accident. And the US went to extensive length to try to protect him and his family while this was all going on. So anyway, eventually, some documents were admitted, but the case, to sort of jump to the end of that particular stage of the case, it settled shortly before trial. Then that seemed to kind of end that chapter, but there was an epilogue about a year later. So last spring, suddenly I got a call and some emails out of the blue from producers at MSNBC. And they said, we'd like to show you some correspondence that we think is relevant to the Prevezon case. And what they brought to me was correspondence between the Russian prosecutor who had responded to the MLAT request, the legal assistance request, and one of the attorneys on the defense side in that case, Natalia Veselnitskaya. So this was a twist. To see Natalia Veselnitskaya corresponding with the Russian prosecutors who are responding to the US government's MLAT request. So two things immediately jump out. I mean, and to take a step back again, the response from the Russian government was also something that you just don't do. I mean, you don't come back and prejudge the merits of the case. I mean, I just want to highlight how irregular that was on a number of levels and say, we think your case has no merit. That's not the way the mutual assistance process works. If you have a question, you have a concern, it gets sent back to the requesting country, and you deal with that question or concern. You don't just flatly refuse and say, you've got it all wrong, your case has no merit, you get no documents. So we always knew it was strange. We didn't know at that point just how strange it was until last spring when shown these documents. So it was a series of correspondence back and forth between Veselnitskaya and the Russian prosecutors. And it culminates with Veselnitskaya sending back, with subject line, final draft to the Russian prosecutors. And what do you know? That attachment of the final draft is identical to the MLAT response that was sent to the United States. So we know not only was this MLAT request shared with defense counsel Veselnitskaya, but she drafted it or had such feedback that her final version was exactly what the US got. And I should note too that as the litigation was proceeding, the defendants were constantly beating us over the head with the content of the Russian response, saying that there was no case, the Russian government says so. Natalia Veselnitskaya would put in declarations in the court case to this effect. And then we find out essentially, the process was not only insecure, but rigged. So that was sort of the development last spring. And then I just want to highlight in terms of lessons, all of this was a profound learning experience for me. But also, in that case, it was I don't want to say relatively harmless, but it could have been so much more serious. Because a discovery like this, you realize, okay, this was a problem. Because we had a civil case, we didn't get the documents we wanted. But thankfully, this was already a filed case. This was already public. So imagine what would have happened Instead, if this had been a pending criminal investigation and we'd sent the same request and it had been shared with, subjects counsel, they had had input into it, I mean, not only would the entire investigation be compromised, obviously, the confidentiality would be entirely blown, but we would be endangering witnesses as well. So I guess what I want people to understand from that chapter is just when that process is corrupted, the impossible position that US prosecutors can be put in. Do you just not ask for assistance in those kind of cases, in which case you just can't bring certain kinds of cases anymore, or do you put the request out there without confidence in the system, knowing that you could be compromising your investigation and jeopardizing your witnesses? That's my bit.
There you go. Tom, batter up.
Thanks a lot. Jamie's case is a fascinating one. It reminds me of a lot of cases that I had. I was a prosecutor in the Eastern District of New York, the neighboring district to Southern District where Jamie was. And I had a lot of cases involving, I specialized in cases involving Russia and really broader than that, the former Soviet world, Eastern Europe, Central Asia as well. And I had a lot of these cases where you had foreigners living in New York with a lot of money and great suspicion that the money was of criminal origin. This is a problem that has gotten worse, and Charles Davidson, who's here, has done a lot of work trying to address the question of what do we do about kleptocratic proceeds filtering into the United States and the West, and how do we keep this out? Jamie's case really illustrates the difficulties with using the criminal justice system to prosecute these cases, because if somebody is here in the United States living on dirty money, they're not really committing a crime just by living in the US. The real crime that you could charge them with is money laundering. The problem with that is you've got to prove the criminal origin of the funds. And to do that, you've got to essentially prove that this factory that they privatized in Irkutsk in 1997 was privatized through criminal means, through bribery or whatever. Try doing that. You cannot do that without assistance from the foreign government. And as Jamie pointed out, when you reach out for assistance from foreign governments, what you get back, in some cases, you just get nothing. In some cases, you get affirmative sabotage of your case. I am aware, I participated in cases, I won't name the countries, where we sent MLATs to foreign countries, and what came back was worse than nothing. It was fabricated, bought and paid for exculpatory evidence. And once you've got that in your case in the US, it becomes Brady material, you've got to turn it over to the defense, and they can use it in your whole case goes away. So these cases are extraordinarily difficult to prosecute. And I say this because at a lot of these conferences, there's a lot of talk about the FBI and DOJ need to do more to prosecute money laundering cases in the US, or the SFO needs to do more to prosecute all these Russians who are living on dirty money in London. It's extremely difficult from a legal perspective to do these cases. And the reason it's difficult comes back to what we're talking about today, the difficulties in international law enforcement cooperation. And Interpol is really another manifestation of that. It's a symptom of this this broader problem. The ultimate problem that unites Jamie's case, the red notice problem that we're talking about, though, is really the absence of the rule of law in so many countries around the world. Again, speaking from personal experience, I saw this when I was working in Russia. A lot of my job for DOJ was to try to promote the rule of law in Russia. Obviously didn't do a very good job with that, to try to build capacity on the part of Russian law enforcement. We had any number of conferences and training seminars for Russian prosecutors, Russian investigators, money laundering, how to use statutes like RICO, et cetera, et cetera. And these are all worthwhile efforts, and I think the interaction is valuable. But one thing that I think we have to keep in mind in our foreign assistance efforts is that it's like a knife is a knife, but a knife used by a surgeon to perform an operation is one thing. A knife used by a mugger to steal money from somebody is something else. And I think that we too often fail to focus on who is wielding we focus too much on the instruments and not enough on the context in which the instruments are being implemented. And to take but one example, anti-money laundering. Again, coming back to one of the points I made this morning about 9/11, that really changed everything. That, increased the focus on international law enforcement cooperation, cooperation. And I think in some ways what we're seeing today with Interpol is the consequence of the reaction to 9/11, a justified reaction, but I think with insufficient attention to the potential negative consequences of promoting, focusing almost exclusively on law enforcement cooperation without paying attention to the due process issues that this might raise. But anyway, coming back to my point, there was a huge effort after 9/11 to get countries to increase their capacity to identify terrorist financing, counter money laundering, track flows of illegal proceeds, all of which was necessary, all of which was good. However, what I have seen in a lot of countries that I have worked on is that these money laundering statutes, which work fine in something like, for the most part fine, in an advanced country with a relatively stable legal system, well-developed rule of law. They're fine here, but when you transport them to other countries where you don't have a rule of law system, they make the problem worse rather than better. And I can't tell you how many cases I saw in Russia of fabricated criminal charges based on money laundering. And it was, I saw a number of cases where, law enforcement, tax authorities, whomever, would find some sort of technical violation in a business's paperwork. They would, on the basis of that technical violation, say the business was operating illegally, make the jump from that to, well, if the business is operating illegally, that means all of its proceeds must be criminal proceeds. That means they're committing money laundering. That means potentially 20 years in prison with the possibility of asset forfeiture. And they would go to business owners and shake them down, extort money from them, threatening them with a money laundering charges, which is an instrument that they didn't have 10 years earlier before this worldwide push to get everyone to adopt money laundering laws. And it's not specific to Russia. We see this in a lot of countries around the world. So I think that our international efforts at law enforcement cooperation, which again are absolutely necessary if we're going to be safe, need to be tempered with an almost equal attention to the due process consequences of what we're doing and the context in which we are promoting these law enforcement instruments. Now, where does that leave us? Promote the rule of law around the world. Easier said than done. We're not going to change the world tomorrow, but as I say, I think everything we do, we need to be much more mindful of this. And we see this in contemporary debates in Washington about countries. I can't tell you how many seminars I've been to on Ukraine. People say Ukraine's got to clean up corruption. They've got to clean up corruption. And I can't tell you how many times I hear people say, we want to see real prosecutions. We want to see people in jail, corrupt politicians put in jail. People who say these things, I think they don't pay attention to the fact that if you just push countries to put people in jail, you get people in jail, you'll get criminal prosecutions, but they may not be done on the basis of real evidence, and they may not be done for legitimate, impartial reasons. So I think that all of our discussion of law enforcement and anti-corruption always has to pay equal attention to due process and the rule of law. And it's not something that's going to be solved overnight, but I think that we can make a difference as we think about these issues and discuss them. So that's what I'm going to say about that. Coming back to our main topic of today, Interpol. Louise was nice enough to give me 2 speaking slots today, and during the morning slot, I spoke generally about some of the problems and the general tendencies, and I wanted to talk briefly about some of the examples that I've seen recently. As Mike mentioned, I have several cases before Interpol right now, one case that involves 3 interconnected cases. And I just wanted to make the point that, as Bruno had said earlier, things I think are getting better in Interpol. Slowly but surely, it's kind of 2 steps forward, 1 step back, but I think there is more transparency there now. If you go to their site, there is some precedent that is published. There's a repository of practice that describes cases, describes decisions that have been reached in cases that one can use to advocate on behalf of clients. I have a case right now, not involving Russia, involving another country in the former Soviet world, where the main defendant, the subject of a red notice, was red notice based on purely fabricated domestic charges as part of a business dispute that the subject had with certain powerful political figures in this country. They destroyed his business, drove him out of the country. He started to fight back, and then they responded with an Interpol red notice, which we have been fighting for several years now. He fought back very aggressively, did a lot in the press in his home country, accusing those who had stolen his business of having stolen his business for corrupt reasons, and then started exposing corruption in his home country. He also tried to get his persecutors on the Global Magnitsky Act, and this was reported in the press in his home country. At that point, the local government responded not with charges against him, which they had already done, but they then brought charges against his wife and his daughter, who had nothing to do with any of his alleged crimes, just as a way to pressure him. We brought all of this to Interpol's attention. They got a red notice against the wife, a diffusion against the daughter. We fought back again with Interpol. We laid out all the cases and all the facts of all three cases. We showed how they were, all the charges were essentially came back to the same scheme by corrupt government officials to steal his business, and that the charges against the wife and the daughter were really punishment against him for having exposed corruption in his home country. And we got a relatively good results so far from Interpol. They agreed to basically delete the charges against the wife and the daughter pending a final review. So they did act relatively quickly, brought this to their attention. They temporarily, pending resolution of the case, they took the charges off against the wife and the daughter. The father is still, the main subject is still on there. But they, were responsive to these arguments when all the facts and evidence were presented to them in a persuasive way. They were responsive to that. We also attacked the charges against the father, and the foreign government at that point then came back and told Interpol, well, it's not just the charges, we have other charges against him. It's not just the charges that, his lawyers attacked in their application to you. There are other charges against him, just as a way of kind of, muddying the waters and keeping, our client on the red notice list. And what turned out, though, when we learned about these additional charges that were posted on the internet site, I spoke to the subject's lawyers in his home country, and in fact, there were no domestic charges against him. He had never been served. His lawyers had been served. They wrote to the general prosecutor's office in this country, which also failed to produce any charges. And what seems to be the case is that the foreign government was able just to tell Interpol that they had new charges against my client, but didn't have to document or substantiate that in any way. And I believe that one of the points made in the Fair Trials report is that charges should always be substantiated by a domestic arrest warrant, so that the government can't just make it up and say we've got charges. They should have to actually document that and prove that. And I think that's that would be a very worthwhile amendment, change to the Interpol system, because it would cut off, again, going back to what we've been talking about this morning, ways to cut off abuse at the front end. I think that would be a good thing, and it's certainly something that I've seen in my case. They're apparently able to just tell Interpol if they had charges without documenting that, and it allows the case against my client to continue based on what seems to be a complete misrepresentation by the home country.
Thanks, Tom. Ben, you want to take us back up to 30,000 feet?
Not sure 30,000, but I'll go for 23,000. So first of all, I want to say that unlike my two or three co-panelists here, I have actually no specific experience in these cases or this area, and so I'm commenting here as sort of an observer of these cases from outside. Tom made a remark in passing in the course of his presentation that I'm going to use as a jumping off point, which is that he said that the fundamental problem in all of these cases is, countries in which the rule of law does not function. And I want to amend that slightly and suggest that the real problem is when countries that do not have a functioning rule of law, their legal systems, such as they are, have to interact with countries that do have functioning rule of law. What is the nature of the interaction of those systems? The nature of those interactions of those rule of law and non-rule of law countries. So I want to make a few points about this. First of all, if you think about the Interpol problem, broadly speaking, it is simply a reflection of that general problem, right? You must have, in a globalized world in which people travel, the ability for countries to alert each other as to pending warrants against people, pending actions. We need to have that. If you think about what happens when you don't have that, that's the post-World War II era where Nazi war criminals spread all over the world, and it took decades to do something about it. And we still have cases where, you find these 95-year-olds in the wrong country, right? You need a system in which we resolve those questions in the face of mobility of people. So the first broad point is that there is no escaping the problem. And this problem, by the way, shows up in 100 different areas. So to go back to some of the points that Mike started us off with in the US civil litigation system, you have to have an answer to the question when a foreign court issues a judgment against somebody, how respectful is the United States court going to be of that foreign court judgment? Are we going to enforce that? You can't not answer that question. You actually cannot answer the question of Chapter 15 of the Bankruptcy Code that Mike also alluded to. For many years, the Bankruptcy Code didn't have an answer to that question. In 2005, it started to have an answer. Bracket the question of whether it's a good answer. That's a reflection of a genuine problem, right? That we now have a globalized economic world, and so a bankruptcy in one country involves people who may be somewhere else, involves assets that may be somewhere else. And Section 1728, I believe that's the Title 28, which is a routine discovery procedure. A litigation exists in one country. The person that's relevant to that litigation is living or residing or hiding or vacationing in another country, vacationing for a really long time. Should a court in country B help a court in country A with its litigation by supervising discovery, by compelling discovery? These are not questions you can avoid answering. There are other examples of that. Those I just mentioned those because Interpol is sort of the subject here, and these are kind of ancillary related provisions that are all subject to, absolutely necessary to have, and B, subject to manipulation by countries that are less than rule of law oriented. Now I want to pause a minute over what the nomenclature of this should be. So the title of this panel is Judicial Interference. In some of our discussions that have taken place in public, the word abuse gets used. And I want to suggest that that's a little bit mischievous in the nomenclature. So when you build a legal system, when you answer legal questions like these, you create litigation opportunities. You either can create them broadly or you create them narrowly. And good lawyers will advise clients, including evil clients, including corporate rating clients, including people close to Vladimir Putin clients, about how to navigate foreign judicial systems. And so we can call it interference, we can call it abuse. What it actually is, I just want to state it very neutrally, is people exploiting their legal entitlements and possible rights and making aggressive legal arguments within the contours of rule of law legal systems. Now, I want to state it that bloodlessly and that unemotionally because I can express anger about it, and I do feel anger about it, but that actually doesn't help. What actually does help is to isolate the policy questions at each level of each one of these questions and figure out what is being permitted to whom that we do not want to be permitted. Now, to go back to the original question which this panel started with, in an environment in which we cannot get routine help with our MLATs, and to give you an idea, I don't know how many of you have ever thought about the MLAT process before. MLATs are an essential core of all international law enforcement. because they are the way the international legal system responds to the problem of sovereignty not being worldwide, right? So if you want to investigate something and it happened in France, but the crime is in the United States, you need help from French sovereign authorities. And the mechanism that we have for that, or one of the essential mechanisms, is the MLAT process. And so when you hear that the answer to an MLAT request, or what should have been a routine MLAT request, is a set of lies written by the defense attorneys, right? You have to understand the magnitude of that system not working. How bad that is not, badly things are not working. So here's the fundamental question. By the way, the other extreme of that, this is outside the context of the subject here, but I think it's important to lay out how broad this spectrum is. The other extreme from that is Congress passed a law last year called the Cloud Act, which allows, under certain circumstances, the United States government to sign agreements with foreign governments, we've signed one with the UK, that allows them to go into our courts directly and seek evidence. So it's basically delegating some of the investigative sovereign authority of the United States under law to a foreign sovereign because we trust the British legal system that much. Okay, so that's the range of, the scope of range of what's possible here. So here's my question, and I think this is what binds all of this together. The principle is comity, and comity is a fiction of international law, and to some extent a fiction of domestic law, that countries are, all countries are equal, and they owe things to each other. Sometimes in the international law community, they call it the sovereign equality of states. Barbados, same thing as the United States. It's a fiction. It's a really useful fiction in a lot of contexts. One of the ideas of that's inherent in this idea of comity is that countries owe one another certain respect for their legal processes. This has always been a difficult idea. This environment is not the first time this has been presented as problematic. How do you, to go back to our example of Nazi war criminals scattered around the world, we had a few that we had to decide whether to extradite to the Soviet Union. They were not going to get a fair trial in the Soviet Union, right? And we did it, by the way. So this is not the first time that we have confronted this set of problems. I think it is the first time we've confronted this set of problems in this manner in an economy and a world legal system that is this integrated and this globalized. And I think the fundamental question that unifies the Interpol issues with civil discovery in US courts, which, by the way, are being used to harass people who used to be in Russia and had ran afoul of the regime, and they live here, and so you come into US courts and you harass them on an ongoing year after year after year basis, and the US courts are pretty vulnerable to that. The bankruptcy code is vulnerable to that. And I think we need to ask ourselves the question, in a bloodless, non-emotional kind of way, what are the minimal standards of rule of law that a country needs to have before we will show that level of comity in our courts that Section 1728 and Title and Chapter 15 of the Bankruptcy Code show? What are the minimum standards? And what does it look like? What would a law look like that gave courts a little bit more latitude to say, if this were the UK, we would of course comply, we would of course enforce this. And because it's you, President Erdogan, President Putin, we're not going to do it. Those are really, really hard laws to write. So a couple more just brief points on why they're so hard to write, and then I'll shut up. Number one, not all failures of rule of law systems are the same. And when you describe, it is possible, and Russia is a pretty good example of this, for a country to have lots of the forms of rule of law and none of the reality of it. It is very hard to write law that gets to the substance that does not rely on form. We can talk about that a little bit more. That's a very hard problem. And the answer, the UK, we know it when we see it. We know Canada when we see it. It's a correct principle. It's a very hard principle to articulate as a matter of law. Number two, and this, I think we just have to be frank about. In some of these cases, the manipulation, and I just spared myself using the word abuse. I was about to, and I stopped. The manipulation of our legal system is ancillary to the use of some other country's legal system. So to me, it is a relatively easy case if dissident X has a giant judgment against them in a Russian court, and a Russian court wants enforcement of that judgment in the Southern District of New York. It's a relatively easy question to me, should the Southern District of New York, it's not an easy question under the law, but under what circumstances should they say, to hell with you, to the Russians? It's a relatively easy question. Here's a harder question. It's a real case, by the way. What if the litigation is not in a Russian court? What if it's in a Dutch court? And what if the initial abuse is not an abuse of the US legal system? Sorry, I just messed up there. The initial manipulation is an exploitation of Dutch law. And what the US court is being asked to do is enforce a Dutch legal judgment. That's a hard question. So bottom line is, I want to submit the following bold, simplistic proposition. This is all about the limits of comedy. It is all about the limits of comedy when non-democratic, non-rule of law systems have to interact with rule of law legal systems. There is no escaping these questions. The answers are going to be very messy. And by the way, we're going to screw up in both directions. And we're going to impair, if you do it right, the result is going to be that some bad stuff still happens and we still feel like our legal system is being exploited or abused, but we're also going to impair cooperation with countries that we actually want to cooperate with. So all of that is to say, it's a hard set of problems, and we shouldn't turn away from it just because it's hard.
Ben, those are great remarks, all fantastic remarks and deeply appreciated. Thanks for answering all those questions. A couple of questions for me, and then we'll open it up to the audience. Jamie, do we actually have a mutual legal assistance treaty with Russia, or is it just requests for assistance?
There is a treaty.
And it exists from a long time ago, I'm sure.
Yes, I don't know the date, but it was in place during the case.
So when we talk about MLATs, we talk about mutual legal assistance treaties.
Right.
That we submit requests via the Justice Department for that information. So when the Russians came back with not only no, but your case is all jacked up, was that typical of other Russian responses in other cases that you may have had experience with? Do you know? Or was this just a special exception where they decided to just throw a bunch of monkey wrenches into this particular one?
I mean, that was the first case of that type that I encountered, so it would be tough to. I imagine it was on a spectrum, a more extreme response. but I can't imagine that there were helpful responses in the past. I imagine that it was between unhelpful or sabotage, something like that Tom talked about. And if I can just sort of like
Sure.
piggyback on your question, I was curious based on what Tom said, when you get the response back that's worse than nothing, that is fabricated exculpatory evidence, what are the options for prosecutors at that point?
Well, I think if the phony exculpatory evidence has been drafted artfully and effectively by professionals in the foreign country, and there are unfortunately professionals at doing things like this, it just kills the prosecution. You can't do it because if your whole theory of the case is that the money in this person's bank account in San Diego is drug money, and they've produced a document that looks official from an employer in a foreign country saying that this was a bonus they received for outstanding performance last year, or a document from a court proceeding that has been concocted saying that this was a payment of a legitimate court judgment, there's not a lot you can do with that. How are you going to prove that it's criminal proceeds when you've got evidence like that staring you in the face? You've got to then go and prove that that exculpatory evidence was itself part of a criminal scheme to obstruct justice, and that's incredibly difficult to do.
So, Ben, you made the point that the comedy is so important and that we assume there's a baseline of legitimacy in foreign judgments, so as an example. So we assume that there's good faith there. Tom, in the Interpol cases, I guess the whole basis of Interpol is you assume good faith by the nation that has published the notice.
Right.
So what do you do when the nation, what are your clients doing when they are faced with a red notice that's published without good faith? And then what are some of the trickle-down consequences of that in the United States? Can you
Well, yeah,
talk a
some of
little
the
bit about that?
trickle-down consequences, and somebody during one of the first sessions made the point that the U.S. and most countries don't arrest just on the basis of the red notice. It's got to go through a judicial process. You've got to get a judicial arrest warrant, all of which is true and well taken. But leaving that aside, what there is not judicial process around is all the collateral consequences of a red notice. The fact that you can't get a job, you can't get a bank loan, nobody wants to do business with you. We're in this era of compliance and FCPA enforcement where every business transaction has to be analyzed very closely, and you've got to do due diligence on all of your business partners. And if something like an Interpol notice comes up as a red flag, most companies are not going to do business because it's just too risky. Because if something goes wrong, you're on notice because there was a red notice out there. So it has tremendous consequences for somebody, even if they're never arrested. And of course, they're not going to be able to travel because they could get stopped at the border. And even if the country where they're stopped at the border doesn't act on the red notice, doesn't start a full, doesn't arrest them and extradite them, they'll be stuck in jail for a few days while they sort it all out, which is a huge unpleasantness, to say the least. So there are a lot of consequences short of the arrest, and I think we have to keep that in mind. What you do when you're the subject of it, as I mentioned, I've had several cases like this, and again, Fair Trials has litigated a number of these cases, and I think it is getting better. As a result of the report that Fair Trials did in 2013, Interpol has created a task force to review red notices. They've improved the staffing in the Commission for the Control of Interpol's files, and there are now people who, apparently from my experience, actually read what you write. You can submit an application. They've got guidelines on the website how to make an application to have your data deleted. It's got to be 10 pages. You can attach exhibits. You've got to lay out certain facts. You've got to provide identifying information. But if you make a persuasive case, I think you can get results, and a lot of people have been successful at doing that. It's not quick. It's not easy, but you can get a result. And so we've gone from a period where I think there was basically no review there, very minimal review there, to a point where there is some substantive review. They've got better people doing it, and there's a lot more to be done, but at least we're seeing a positive trajectory there in terms of review of complaints.
Or is there a typical timeline on?
I mean, in my experience, I think they're supposed to make a decision within 9 months or something like that. But the problem is that a lot of times they ask for additional information. They go back to the requesting state, they oppose the application, and then they come back to you as the applicant seeking additional information. So it can take a very, very long time to litigate these things. But it's better than nothing. So, but these cases, one thing that became clear from Ben's discussion is we can't draw bright line rules in these cases. You can't just say every country is, we're not going to accept any requests from country X or whatever. And I think, in fact, it's even more difficult than that. And often the worst abusers, the countries that are most corrupt, also produce the most real transnational crime, the most drug dealers, the most mobsters, most money launderers, precisely because they're so corrupt. They provide environments in which drug dealers and whatnot can operate. So those that are the worst abusers are also the ones that we need to cooperate with most at the same time. So I don't think we can really draw the kind of bright line rules and just kick countries out. What became clear to me when Ben was talking, we really need to look at each one of these cases on its own specific facts. It's a very case-intensive, fact-intensive analysis, and that's why these things take so long. But I do think because of all the attention that's been focused on Interpol, they're now taking these things more seriously, and you can get some relief there. It's not easy and it's not fast, but it's possible.
It sounds like a bad combination, a Kafka novel or a Dickens novel. I'm not sure
Combination. It's a great way of
Can I
putting
just
it.
add something to that? The other factor, so Tom just made 2 points that I think are really focused on. There's an old Yiddish expression, even paranoids have enemies. And it's even non-rule of law countries have criminals, right? And the fact that they, the fact that Russia doesn't have a rule of law system doesn't mean there's not a lot of serious criminality there that authorities may actually have legitimate interests in prosecuting. And so it is very easy to, and the other factor is that sometimes, and this is where it gets really complicated, politically motivated prosecutions can also be meritorious, right? And and so there's a very difficult set of line drawing problems anytime you're trying to draw the lines as a matter of principle. The other point that Tom just made that's really, really important is that we do not, at the end of the day, want less law enforcement cooperation with some of these countries. The biggest, if you spend time in the cybersecurity arena, which I do, a immense percentage of that problem of cybersecurity criminality, as opposed to state-level issues, stems from a relatively small number of countries, all of which we're talking about today. Russia, Ukraine, Romania, China, and whatever the answer is, it can't be that we don't improve in the long run enforcement cooperation such that these sets of problems, and there's all sorts of other problems that fall into the same category, we have less cooperation on them. So, that doesn't suggest what the answer is, but cutting countries off entirely from international cooperative law enforcement is a total non-starter.
Tom.
Oh yeah, I just wanted I agree entirely with Ben's point. I would even take it one step further. I wouldn't say even non-rule of law countries have real criminals, but especially
Yes, exactly. non-rule
of law countries have real criminals precisely because they're non-rule of law countries.
I was just trying to make a parallel with with the old Yiddish expression.
Ben also makes a really great point about the politically motivated prosecutions that are where the person's really guilty. I've seen a lot of the cases I've worked with in Eastern Europe, the former Soviet Union. The person is a criminal. The subject of the investigation has committed crimes. That's not the reason why they're going after them, and they're not charging them with what they actually did. They're charging them with something else, and they're charging them because they want to get rid of them, they want to steal their business, they want to drive them out of politics. But the subject is, in fact, guilty of crimes along the way. To me, those cases should be judged just like any other case. If there is real evidence against the person, and it meets certain evidentiary standards, it can be proven in a court of law, the fact that they're also a political enemy of the regime should not immunize them from prosecution. But in most of the cases that I've seen, they're so sloppy, they get the order from on high to go after this person for political reasons. They throw together a crappy case that could never stand up in court, and it's very easy to show that it's politically motivated and it doesn't meet legal standards. But if it meets real legal standards, to me, it should be entitled to be prosecuted, because otherwise you get a situation where you have real criminals going into politics saying something against the government just to immunize themselves from from criminal prosecution, which we also don't want.
And this is something U.S. prosecutors face too, right? I mean, that there would be attacks on the prosecution for the motive of the prosecution, and there's a reason that it's regularly a motion to exclude before trial to discuss the prosecution's motive in bringing a case, right?
One more question, maybe it's for Jamie or Tom. If you have a case, you have a client who's stuck on one of these red notices, do you have like a mini trial at the district court about the efficacy of the foreign notice? Is it some poor U.S. district court judge who has to decide that the Russian system is not legitimate, or?
No, I mean, in Interpol, there's no judicial review at all. There's no review in the national courts. So the only adjudication is really on the papers in Lyon at Interpol headquarters. You submit these applications. I think in some cases they may have some oral argument, but as I understand, that's a rare exception. That's the only adjudication. There's no real remedy in domestic courts for a red notice. Now, if there's an extradition proceeding, then of course there's going to be something in the domestic courts. But if it's simply a red notice and you want to get rid of it, there's nothing to do in the domestic courts.
I guess I was thinking about maybe in the context of someone coming in the United States seeking discovery, and the defendant in the United, or the target in the United States saying, no, you can't grant that request for discovery assistance.
That's a great question.
That stuff is in district courts all over the place.
So the judges are then opining upon the legitimacy of the request.
I mean, they have generally taken the view that they're not going to spend a lot of time looking at the sort of public policy implications of honoring the thing. The different statutes give them kind of varying levels of authority to do that. They've been very deferential, and as a general matter, and so look, I mean, I think I think having a little bit more statutory guidance on that in a variety of areas would be super helpful. I also think if you had a lot of, if you give district courts a lot of latitude to make those judgments themselves, there are 700 U.S. district judges and 100 or so Circuit Court of Appeals judges. You're going to have a lot of diversity in the federal courts about which legal systems are entitled to what level of respect and under what circumstances.
Great billable hours, no doubt. We are not quite done, but are there questions from the audience that folks may have?
Thanks very much.
Never fails. Speak loudly.
There it goes.
There we go. So I have two questions, and I hope they don't get lost. They're kind of related to each other. And they're against the backdrop of, let's say, Russia being a jurisdiction where they're very good at the procedural mechanisms of the law and the rule of law, but when it comes to the content, they're lacking, let's say. So what level of trust, and we've sort of hit on this, and all of you sort of hit on it, but I want to sort of press the issue. What level of trust or scrutiny should U.S. courts be applying to, let's say, Russia when it appears as a litigant in the U.S. court or one of its agencies? And the related question is, which is also important, is how do we as lawyers, as litigators, educate judges who we appear before them, and let's say in a Chapter 15 proceeding or in a 1782 proceeding where the court is being asked to supervise discovery and grant discovery, how do we say to a judge, this is coming out of a corrupt system and this is play-by-play out of the corruption playbook? Judges, from the cases that I've seen, have generally said, like Ben was saying, we're not going to look at this. Or alternatively, they say, look, just because Russia's corrupt doesn't mean that this case in particular isn't worthy of having discovery. And sometimes, and oftentimes, like in 1782, the statute might not give them the authority to do that. So, but how do we educate judges to know to look out for these types of things?
So let me take a crack at that. First of all, I want to suggest that the first address for that education is not judges; it's members of Congress. And 1782 is a statute that got written, and it is a statute that could be amended. And I don't know, I've never kind of written in my head what the amendment of it would look like, nor have I spent enough quality time with the case law under it to sort of have a sense of I have a sense that it's really off. But I have a sense of how exactly it's off and how badly. I would have to spend a lot more time with the statute than I have. The first problem here is not how judges are reading that statute. It's the statute itself. And I think, so the first question is, what guidance should Congress be giving judges on that? And I would suggest that's a question in the first instance, that people should be talking to the Senate Judiciary Committee about. And that there's a long-term process of talking to the people who are ultimately responsible for the content of those laws. Now, in addition, a lot of judges have behaved in a head-scratching way on this. And other than having really good expert witnesses which has, by the way, has happened, and working each case really well and explaining the way this manipulation is happening, I'm not sure what else you can do about it. But I think as long as the law is what it is, it's going to be manipulated. I don't know. Do you disagree with that? Sorry, I didn't realize you didn't have the microphone anymore.
You've left them speechless.
It's not
Take
that
away the mic and anyone's speechless.
I don't necessarily disagree with that. But what's happening in the meantime is judges are being asked to adjudicate on the legitimacy of a jurisdiction's adherence to the rule of law. So what do practitioners do when presented with this kind of problem, where the statute says do X, but you're asking a judge, how do we help judges adjudicate whether or not jurisdiction X is a true rule of law jurisdiction?
So I am not a litigator, and I am badly positioned to advise you on that.
I think Tom may have.
But I will say this: we have vehicles that Congress is going to consider in the next year on Russian, new sanctions legislation, and there are legislative vehicles where people should be thinking about this.
Tom.
Well, I was, sorry, I'm not moderating this, I just still have the microphone. But I was curious about what Tom and Jamie have to say, and then the follow-up question to just my earlier question is, should there maybe be, some of you had alluded to maybe approaching this with a sliding scale approach when deciding whether or not a certain jurisdiction or a certain jurisdiction or a certain court is or is not a rule of law jurisdiction. But yeah, thank you.
Sure. Just to go to your first question, you asked what kind of scrutiny should Russia get when it comes into a U.S. court? To me, it should get the same scrutiny every litigant gets. I clerked in federal district court, and we had lots of charlatans who were born right here in the U.S. come into court and try to put one over on the judge and make dubious representations, and judges have to scrutinize that. So to me, every litigant, everybody who comes into court, everything they say should be scrutinized. It has to be that way. Russia has their cases, like we've talked about, but we got to be careful not to go the other way. During our lunchtime talk, we heard about Vyacheslav Ivankov, one of the worst Russian criminals ever. He spent 9 years in prison in the U.S., and I remember he was sentenced in my district, and at his sentencing, one of the factors was his prior criminal record in the Soviet Union. He sure enough came in and claimed that this was because he was a dissident and he was opposing the Soviet regime. In fact, he was just a pure mobster, plain and simple. And so we've got to look look at these things very much on a case-by-case basis. So everything they say should be scrutinized, and that's what our adversary system is good at doing. In terms of how to educate judges, I think you do that the way you do. We educate judges as litigators all the time about complicated medical issues, and I think you do that the same way you do in any other case. You have expert witnesses. Louise served as an expert witness in Jamie's case, and that's what we do as lawyers. We put together evidence, we put together expert testimony, and we present it to the judge in a persuasive way. So I feel like our system has the mechanisms in place to deal with this problem.
I would agree with Tom on the use of experts and the use of Louise in particular. I mean, but it is effective because you know if you have a
Worth
clear,
every penny.
concise expert who can say, here's why there are red flags, just sort of educating the judges on the red flags in the process or the fact pattern and explaining that this fits a particular pattern and drawing parallels to other historical examples of corrupt cases, I think really does land with a lot of judges, and it can be done effectively.
Last one?
I respect you as experts, but sometimes people actually doing like experts, and they bring to court some research about the situation from Russia. I know some people who work like experts, but they are not experts. They like cheaters, for example. Yeah, they can bring with people to court their research, but it's wrong. They don't understand. Okay, I know how it's working in Russia. I know how can receive any court decision. Okay, you know because you work there, you read about it. But people doing something wrong, and it's go to the court and judge look at this. Okay, it's wrong. He can understand it, but. Maybe I'm agree with my colleague. Maybe we need to do something to education judges and then explain them how is it working. It's not like
But that's what lawyers do in every case. You explain complicated things to judges over the opposition of somebody who's trying to convince them that everything you're saying is a lie. And you got to have better experts, and you got to explain it persuasively and document it very thoroughly.
not everybody knows about experts.
And on that
Take
note,
Louise.
the one more? We got 3 minutes.
Okay. Thank you very much. This whole discussion makes me think not of a Yiddish expression, but I think it was the famous Venezuelan strongman that, for my friends, anything, and for my enemies, the law. And it seems like the simplest explanation goes back to Tom's opening statement and possible reforms that would allow us to continue cooperating on counterterrorism and cybersecurity and all the vital areas by simply narrowing the scope of cases that can be used for red notices, limiting the range of possible abuse or exploitation of that process. We've talked about reform at Interpol and some progress. How much appetite do you think there is within the organization to do such a thing, to limit economic crimes, to have some of these stricter measures? And for those of us who don't follow the institution closely, walk us through what would be required to propose changes like that. Would it be another amendment to Interpol's charter, or what, to just simply strip away some of the low-hanging fruit that is enabling abuses of the red notice system? Thank you.
Tom, am I correct?
Yeah, I mean, you've touched on a huge issue. I think there is a lot of appetite in Interpol to reform, and they're getting very sensitive to these concerns. Again, I urge everyone to read the recent Fair Trials report that just came out in October of this year, and it details the cooperation they've had with Interpol and the changes that Interpol has made in response to the earlier criticism. So I think there is appetite there to improve things. They don't want to be seen as an instrument of human rights abuses. Whether or not there'd be appetite for limiting the number of crimes that are within the scope of red notices, I have no idea. I don't know if anyone's proposed that yet, but I think that would probably require an amendment to the Charter, the Constitution. But again, what the appetite is for that, I have no idea, because I don't know that anyone's raised it before.
It's a great subject for hearing at the Senate Judiciary Committee. And on that note, we're out of time, so the case is submitted. Thank you to the panelists. What a great discussion. Really appreciate it.
Thank you.